Okay, let's go ahead and get started. Good morning, everyone, and thank you for joining us today. Today's session is entitled Adjusting to the Teleworking Environment, Tax and Employment Laws to Consider. And our two presenters today are Judy Barnhard, a Senior Vice President at Councilor Buchanan and Mitchell, and Thomas McCally, an Equity Partner at Carr Maloney, an area law firm. For those of you who've been on our calls before, I'm going to go over some housekeeping items. The first one is to just make sure that as you're joining the meeting, please make sure to mute yourself and also to keep your video off as a courtesy to the presenters. For those of you who submitted questions beforehand, those have been submitted to the speakers. But if we don't have an opportunity to answer all your questions during the next hour or so, please feel free to reach out to our presenters afterwards. Their email address is going to be included. We will be sending the presentation slides after the session, and this meeting is being recorded. If you do have questions throughout the presentation, please feel free to use the chat box. There is a lot of content, so our presenters are going to be focused on going through the slides and answering questions afterwards. And with that, thanks again for joining us, and I'll turn it over now to our presenters.
So good morning, everybody. This is Judy. I'm actually going to go through and introduce myself, and then Tom will do so when he gets to his slides. I am a partner at Councilor Buchanan and Mitchell. I'm the chair of the Professional Services Committee here at the firm. My area of specialization is in tax and financial planning and advisory services. And in addition to being a certified public accountant, I am a certified financial planner and a certified divorce financial analyst. We have about 44 slides today that we'll be going over. We have a lot of content to share with you. We're very excited about this presentation today. We will try to incorporate the questions that you've sent in advance. We appreciate all of the interest in our program. And we are trying to leave some time at the end of the presentation to take questions through the chat box, as Joe mentioned. So with that, let's get started. We're going to jump right into what we're calling how COVID temporary shelter in place rules will affect businesses. All of you employers know, obviously, that your employees have been working remotely, either from their homes. They may be at their vacation homes. They may have moved back in with their parents. They may be going between 1, 2, or 3 different places at once. It's creating a really difficult environment to determine where, in fact, a business is taking place. And so we're going to be reviewing those rules with you today. I want to start by what the definition of Nexus is. Nexus is essentially the nature and frequency of contacts that an out-of-state company must establish before being subject to tax in that state, essentially. And if a company is subject to tax in a state, then the business may pay, collect, remit taxes in more than one jurisdiction. So the question is, what creates nexus within the state? And typically it's a 2-pronged factor. It's an economic nexus and it's physical nexus. Before we go to the definitions of those two, I'm just going to jump into, some people may think, well, what's the legality of this? How come a state can just go ahead and tax my business? And it's interesting, we have, different rules here. The Article 1 of the US Constitution has what's called the Dormant Commerce Clause. And that clause basically says states can't discriminate against interstate commerce nor unduly burden. So taxpayers must have some minimum economic contact with a state in order to be subject to tax. That goes back, as I say, Article 1 of our Constitution. But then comes along the 2018 Supreme Court decision, very, very big decision for taxpayers, South Dakota versus Wayfair. Of course, Wayfair is the company that's sending, furniture, fixtures, whatever you want to buy off their website to consumers in all 50 states. And so in this Supreme Court decision, the state said the states can mandate that business without a physical presence in that state can make them subject to sales tax. So that's I would call a decision in favor of the states. The dormant clause is really more in favor, I think, of the taxpayer. Public Law 86272 was adopted in 1959, and it says essentially the states shall not impose a tax on income derived if solely from just solicitation of orders of personal property in a state. So just kind of keep that in mind. I think as we go along, you'll see we're talking excessive taxation and withholding requirements this year and beyond. Definitely will be conflict between states, as we're going to show. Employers need to obtain data about their teleworking employees' locations. And I think, we're going to address at the very end, is the federal government going to be doing anything to help kind of navigate this situation? So what is the home office convenience of employer test? Many employers have heard this. Essentially, it's if work is performed at the home office that could just as easily have been performed at the employer's office, then it is for the employee's convenience and not the employer's necessity. Thus, the nexus in this case is the business location and not the home office. In order for there to be nexus in the employee's home office, there generally has to be some compelling reason, as we were just saying with the dormant clause, some compelling reason as to why the work has to be performed out of that location, whether or not it's proximity to specialized facilities or other effort that the business has made to call that a bona fide office of the business. Where the employee officially works may also impact their ability to be reimbursed for home office related expenses. And we've had some of the questions that came in specifically were, well, I'm working from home now and I'm incurring expenses. Can I deduct, such expenses from my income taxes? And here I'll just remind people that the 2017 Tax Cuts and Jobs Act eliminated deduction for unreimbursed business expenses as a miscellaneous itemized deduction. So as a W-2 employee working remotely from home, if your employer is not helping offset some of your expenses, you're unable to claim a deduction on your personal tax return. Okay, let's see. How COVID temporary shelter in place will affect employees. When a person lives in one state and works in another, they absolutely can incur tax liabilities in both states. 7 states tax people where their office is located, even if they do not actually work in the state. These so-called convenience rules states are Arkansas, Connecticut, Delaware, Nebraska, New York, Pennsylvania, and just recently Massachusetts. So the 6 states other than Massachusetts had the convenience rules prior to the national state of emergency for this year's pandemic. Massachusetts added it after the pandemic. Massachusetts is seeing apparently many of its employees working out of New Hampshire. And this has caused quite a feud. As you can imagine, New Hampshire does not have a state income tax. And so consequently, there's going to be some issue between New Hampshire and Massachusetts about who is actually taxing these individuals. And the individuals have to pay tax to Massachusetts, even though they are working from their home state of New Hampshire. Fortunately, most states do allow a credit for tax paid to other states that's claimed on their personal income tax return. Okay, now we'll get to the actual definition of economic nexus and physical presence. Economic nexus is not a bright line rule. There are some states that have a test, such as shown here, California, 602,000, Connecticut, 500,000, and New York, 1 million. But many states have other rules that are maybe not quite so generous in terms of the bright line revenue test. But economic nexus is essentially how much income has been generated from within that state. Physical presence is strictly, where the company is doing business. Does it have brick and mortar company location? Are there remote employees, like permanent employees, working from their home in a particular state? And then this begging question is, would a telecommuter create physical nexus given the shelter-in-place orders? Bloomberg Tax held a survey, this 2019 survey of state tax departments. And that survey results says virtually all states indicated that the presence of 1 to 6 telecommuters in the state would give rise to an income filing obligation in that state. So that gives you some idea of what states think about having the telecommuters in their states. Definite takeaway from this presentation is that, this is not a federal thing. This is a state issue, and each state has its own rules and thresholds. And there's due diligence for complying with each of the state rules. A lot of variety leads to a lot of complexity, and this certainly will lead to a lot of confusion this year and beyond. So here are some of the taxes that employers are subject to with regard to payroll. There's the FICA, Medicare, and FUTA taxes, but now we're talking about the state local income taxes, and the threshold does vary amongst the states. 41 states impose a personal income tax. Of those 41, 24 states require employers to withhold tax from a non-resident employee's wage beginning the first day that the non-resident employee travels to that state. That's 24 states. That is a very, very low threshold. That's saying first day that employees in that state working for your company, you're required to start withholding tax. State unemployment, there's a 4-prong hierarchy to determine which state the unemployment tax is paid to. Essentially, unemployment tax is only paid to one state for each worker. Workers' compensation, Tom's got a section on it coming up, but just food for thought. Workers' comp covers employees working in any location of the employer, begging the question, is the home office now that the telecommuter is working from a location of the employer? And thank goodness we have some exceptions. We have what's called reciprocal payroll tax agreements. What is a payroll tax reciprocal agreement? It's an agreement made between neighboring states that basically establishes where an employee is taxed. And example, in our area in Washington, D.C., it has a reciprocal tax agreement with Maryland, Virginia. And you can see from Maryland, Virginia, Pennsylvania, and West Virginia, these are the states that have reciprocal tax agreements. So let's just take an example here. If you live in Virginia, but you're employed in North Carolina, which happens a lot actually down in the kind of the Tidewater area. North Carolina doesn't have a reciprocal agreement with Virginia. So North Carolina is going to tax the salary of the individual that's working in North Carolina. But now the individual is not working in North Carolina, they're working in Virginia because they're working from their home office. So in this case, the employee would be filing a North Carolina non-resident return. They'd be filing a Virginia resident return, and they'd be claiming a credit on the Virginia return for taxes paid to North Carolina. Okay, that sounds fine, except that the marginal rate in the two states is different. In this particular case, North Carolina is 5.25% and Virginia is 5.7%. So not a huge difference, but you can see, just as this example can happen, that not every state has the same tax rate. So you really are comparing the rate of the tax that you are working in versus your home state. Other types of business tax to consider. Obviously, if you create Nexus, now in a state, not just the obligation to withhold income tax for your employees, but also there are state and local business income tax, sales tax, personal property tax, and many states have a gross receipts tax. How do you determine revenue to that state? Typically, there's what's called an apportionment method, and under the apportionment method, there's a three-part factor: sales, property, and payroll. And some states will have a single sales factor. Some states will weight the sales factor more than the property and payroll tax. Again, it is by state, so you have to know the state rules to comply. And sometimes there is a separate accounting method or alternative apportionment factor. In the DMV, Maryland uses the three factors, phasing in over 5 years to just a single sales factor by 2022. And DC uses a single sales factor unless you're a financial institution or transportation company. Virginia uses 3 factors with double weighted sales. That kind of gives you an idea. Will states reconsider the apportionment factor? Going forward, I just read an article in the Washington Post this morning saying a lot of employers are not anticipating their employees to be back at their offices until next summer of 2021. So this is not just a 2020 issue. This is going into next year for sure as well. And these apportionment factors, may be reconsidered. Obviously, the swing in payroll factor could be significant. And then keep in mind, if your payroll factor is in that state and they're working out of an office that's deemed to be a business location, they might have business equipment there. So that would also impact the apportionment. Other issues to consider, obviously, the state registrations, local registrations. The District of Columbia has a requirement to register your home office. So it's significant, the compliance once you've established Nexus in a particular state and or city. So hopefully we might get some federal relief. My own view is that we're not going to see anything until after the election, but there are 3 bills, which I'll just cover briefly, 3 bills right now, 2 in the Senate, 1 in the House, where the government is trying to potentially help, kind of navigate the problems that it will exist between the states. The Remote and Mobile Worker Relief Act of 2020 is introduced to Congress in June of 2020. It's in the Senate. And it basically would say through December of this year, which doesn't seem that far away anymore, prohibit the imposition of state income tax and withholding for employees temporarily working in a state due to COVID for less than 19 days. And it would provide Nexus relief for purposes of imposition of state business taxes due to employees temporarily working in the state. This is right now in the Senate Finance Committee, and all 3 of these bills I'm just talking about, none of them are law. They're just bills that have been introduced for consideration. The Health Economic Assistance Liability and Protection of Schools Act of 2020, this is also was introduced into the Senate this year, would exempt employers from liability under federal law and employment laws for actions to comply with public health guidelines. Includes a temporary provision which partially restricts double taxation through 2024. So at least that one is looking further out. Remote employees would only be subject to income tax in their state of residence and in any states where they work for more than 90 days during the calendar year. Similar theme to the other, the Remote and Mobile Work Act, a 90-day kind of threshold and 30-day threshold for calendars year 2021 to 2024. And then there's the Multi-State Worker Tax Fairness Act. This is actually in the House, and it was introduced in August, and it would limit the authority of a state to impose an income tax on the compensation of a non-resident employee to the period in which the non-resident individual is physically present in the state. So hopefully we will see something coming out of out of the federal government to assist with this. In the meantime, the states have gotten together, and there's 13 states that are providing a temporary waiver for state withholdings and tax liability for remote workers working in different states during the pandemic. And you'll see those 13 states listed. Separately, 15 states have gotten together and said they will provide relief from creating Nexus within the state due to telecommuting employees. So in summary, I think you'll see that the rules are complex. They're burdensome for sure for the employers. They're burdensome for employees. I would seek advice of a tax professional. And in terms of resources, the American Institute of Certified Public Accountants, AICPA.org, is following this closely, and they have also been lobbying on the Hill to try to have Congress help out to the situation. And I would encourage you to contact your, congressmen and senators to support these three bills. Try to get them out of committee and actually get some bipartisan action on it, because we certainly need this before the end of the year. And with that, I'm going to turn it over to Tom.
Thanks, Judy. My name's Tom McCally. I'm an equity partner with the firm of Carr Maloney. We have offices in Washington, D.C., Maryland, Virginia, and West Virginia. I head up the labor and employment practice at the firm. My presentation today, and like Judy said, we have a lot to cover. The main goal of it is to make certain all employers are aware of the statutes that relate to COVID-19 in the workplace. Those statutes are listed here on the page. They are changing. There are regulations and guidance that are coming out from the Department of Labor, from various state and local jurisdictions that are changing their laws to adapt to COVID-19. And the reason it's important to be aware of these, we do expect, at least the literature expects, a wave of litigation related to COVID-19 in the workplace. That could be whistleblower claims for not providing a safe work environment. It could be direct claims for injuries, illnesses, etc. And employers, much like Judy just covered, can't wait or even expect to rely on liability shield litigation. The federal government has been unable to pass it. The states that have passed any type of shield laws for employers or businesses in general, they also have provisions, it's not complete shield, that allow suits to be brought if the entity, and in this case an employer, is acting intentionally or with gross negligence, willful, wanton indifference. For example, you failed to provide or follow the CDC guidelines for returning to work and providing hygiene, etc. With that, following and understanding these laws and following their guidance now is an employer's best defense to any claim. What are the claims going to be? We don't know. They're going to be novel. There's probably going to be class actions and the like. And there will be enforcement actions from entities like OSHA, Department of Labor for Fair Labor Standard Act violations. So the most important thing to take away from this is understand which laws apply, understand what you need to do to comply. Third, show that you complied, your due diligence, make sure you document it. And then if litigation comes, you're going to be in the best position to defend against claims that could come down the pike in the future. So with that, we'll move forward to the next slide. OSHA, not many of you deal with OSHA a lot. Law firms, accounting firms, offices are typically excluded from the reporting requirements that deal with reporting injuries and the like. All employers, however, have to report serious injuries and those include death, amputation, loss of an eye, or a hospitalization. And that's one of the issues with COVID-19. So OSHA does look at all employers as being covered, even if you don't have regular reporting requirements. Some of the claims we're seeing already, this is an example. There are 16 related COVID cases brought by OSHA and their enforcement arm. They are moving forward. They haven't been very aggressive. Most of them have been in the healthcare industry and manufacturing, but OSHA is getting active and bringing those cases. And whether OSHA brings them or not doesn't mean that there's not private litigation. This is a suit against Amazon. Workers are claiming they have not been provided a safe work environment. This claim is brought under the public nuisance theory. Amazon's defending and arguing that this should be kicked out of the courts because it's something OSHA should address and not the courts. So this gives you an idea of the type of litigation we're looking at coming down the road, and there's going to be novel arguments brought. What does OSHA require for remote work? This is good news for the employers. This guidance was put out in 2000. It has not changed. There has not been updates to it. So bottom line, OSHA is not really going to get involved in home offices, inspecting them or fining employers, at least at this time. Even though the guidance is old, remember, OSHA still applies. You have your people working out of their home. OSHA still has jurisdiction. So if there is an injury, it should be reported if it meets one of those qualifying factors I talked about earlier. Hospitalization is something that could be covered through COVID exposure, and the person is then hospitalized. Understanding that OSHA does apply here, what should employers do? There are other laws that impact the working conditions in the home, such as workers' comp, et cetera. But with your people working at home, you want to implement policies that are going to protect you. For example, don't allow coworkers or clients to go to your employee's home unless absolutely necessary. Try to limit any work engagements in an individual's home other than the individual working. And the requirements for reporting a work-related injury from a virtual location, be it a home office or another workplace. Number one, the injury has to have occurred while you were working and being paid. Number two, it has to be directly related to the work. And here's an easy example. Employee has a box of documents, drops them on his or her foot, breaks his or her foot, goes to the hospital. That's directly related to the work. That would be reportable. Number two, employee stands up, trips over their dog who's hovering around their feet. That's not related to the workplace. That would not have to be reported. So just keep in mind, if there is a workplace injury from the home, think about OSHA and whether or not you have to report it. OSHA is also giving guidance along with the CDC, Department of Labor, about the return to work. And all of us are in some phase of either pure virtual, hybrid returning, and there are a few who are back to work full time. With that, you need to understand as an employer what OSHA puts out there and what they expect you to do. There's a link here to the booklet created by OSHA. This is going to be one of your best pieces of evidence if there are future claims, that you considered the booklet and what they recommended and that you implemented it and document it so you can show it. To sum it up, since we don't have a lot of time, number one, perform a hazard assessment. That means walking throughout your workspace and looking where people could be exposed to COVID-19 on the job. What's the result of that? In conjunction with the CDC guidance that we'll get to, you see posters being put up, spacers in the lobby of buildings or in your own workplaces. shields between workers who are working in an open area. Number two, during all phases of reopening, they want the implementation of basic hygiene. So what do we see from that? Number one, the sanitizers everywhere. Number two, social distancing notices and warnings, a system to identify employees who report exposure or who are sick from COVID-19, and what you do to follow up, and a policy that you're going to implement with that. And then training your employees for each particular phase. How do you do that? Very easy. Emails out to your staff about what you expect when they return to work. Have the policies written so there's no dispute that you did it. And finally, OSHA, like the CDC as well, is requesting and demanding, frankly, that you be flexible in your working conditions now. As long as we are in lockdown of whatever degree, depending whatever state you're in, they do want employers remaining flexible and considering flexible workplace options, whether it's in the workplace, hybrid, where you come in part of the week or not, or just purely working remotely. Understand that that's what OSHA is looking for. Your policy should track that. That will be a good defense for you if there is future litigation. The next area we're dealing with is workers' comp. Workers' comp still applies to the home office. This is the federal statute. You need to be aware of your state statutes. But with workers' comp, if someone is injured in the home while performing work, that's a compensable workers' comp injury. That needs to then be reported, and the employee needs to be provided the forms. There may be a dispute whether they were working, where were they in the house, or their workplace, virtual workplace. But keep in mind, if someone reports, then that may be an injury that you need to report under workers' comp. I would also expect we're going to see, if not a wave, at least claims about people who are suffering injuries while working because they have an improper office setup. It's not ergonomically correct. For example, the carpal tunnel, claims like that, or other injuries like that. If you hear employees complaining about their workspace at home, to avoid a workers' comp claim, consider providing them what they're going to need to work remotely. Because keep in mind, there's no telling when this is going to come to an end, or if it comes to an end, what that will look like. So better to provide what the employees need than ignoring those types of requests. Moving on to CDC guidance for remote workers. Again, if they're working remotely, it is a workplace that you're responsible for. You should continually be checking the CDC guidance and your state and local guidance for what they say about employees working remotely, and follow that. Again, what's the best way to do it? Follow the CDC guidance in your own policies. Now, if you have employees working remotely, some employers are asking them to certify that they have a safe workplace. We see that being done with forms, checklists, and asking the employees to submit those. If employers see an issue, they react and get the employee to correct it, or they may very well correct it themselves. One of the most important issues is what happens if your remote employee becomes ill or thinks they were exposed. You should follow the CDC guidance in that case, just as if the employee were in the workplace. And that will get to the CDC guidance a little later in the presentation. But again, there's a link here for the guidelines. Best practices are following the CDC guidelines, and your best defense if there is future litigation, to be able to demonstrate that you not only implemented them, but you trained your employees on them. Here are the specifics for employees working remote who test positive, report symptoms, or may have been exposed to someone who has COVID-19. So it's very similar to what you do if they're working in the office. Number one, advise them to quarantine and seek medical assistance. Number 2, always remember your sick leave policies and the FFCRA, the Families First Act, provides for paid leave. A lot of that act, they may have already exhausted that benefit because it's limited to 2 weeks for the individual, and it goes up higher for taking care of children or family members. But that doesn't mean they don't have access to family medical leave. And depending what state you're in, if you're in DC, for example, you're going to have expanded family medical leave that could also apply. Just like in the office, make sure you limit contact to coworkers. You don't want any of your coworkers going over to visit. You don't want meetings in that employee's house. Make sure that employee knows that and does not let anyone come in. Now, what if they want to continue working? If they think they're capable of working, you should let them work. Again, you should be smart about it. Make sure they don't exchange papers or other work material with other people. No face-to-face meetings with clients, customers, etc. But they are allowed to work. Otherwise, you could run afoul of ADA laws and guidance on that and treating them as, quote, disabled. And we'll get to that in a bit. So just because they're positive or were exposed does not mean they have to take leave if they're capable of working. The next area where we're really expecting, and we're already seeing it, a wave of litigation comes with wage and hour laws under the federal statute or the state and local wage and hour laws. And what we're talking about here, you need, just like always, make certain that you have accurate record keeping. Make certain that the employees know all work is to be paid for. Excuse me, losing my voice. This becomes particularly problematic with virtual work. We have employees who are texting at all hours, who are calling at all hours, et cetera, and asking, I apologize. And all of that type of work needs to be compensated. One good piece of good news, the Department of Labor has issued a couple pieces of guidance. If you're going to allow breaks for childcare, that does not have to be compensated. There could be other reasons for breaks during the day that you're going to allow. If you're not going to compensate those, make sure it's scheduled and that there is a document indicating no work is to be performed during that period. If you have that in place, then you're going to be in the best position to avoid a wage and hour claim down the pike. Now, what is expected in terms of keeping these records and with the new DOL guidance, what should you do? You want to make sure your record keeping policies are sufficient to allow employees to record all time. Just do an audit of your policy to make sure they can put in if they're working late at night, over the weekend, etc. If you have that policy, the DOL guidance that came out just last month, if you can show you have that in place, you're much likely in a better position to defend against a subsequent overtime claim. And we all know how those come about. The employee leaves, they're disgruntled, they file a wage and hour claim saying they worked all these hours on the weekend, late at night, but never put in for it because they didn't know how to, et cetera, et cetera. This DOL guidance, as long as you document it, is going to give you a good defense against such claims. Now, always remember, with wage and hour, the employer bears the burden of proving the work was not to be performed. Okay. How do you do that? Your policy. They're only to work 8 hours or whatever your normal work day is. not allowed to work beyond that unless they have approval. The DOL also says merely putting out such policies is not enough. You have to show you enforce them. What does that mean? Disciplinary action for employees who continue to violate your policies. If you have those three elements, you're probably going to be in a good position to defend against a wage and hour claim down the pike. And again, the literature is expecting a lot of these because of the looser working rules with remote working and not working in the office. Get these policies up and out so your employees can see them. Always something you might want to consider, and we have it later in the presentation, but a hub, an HR hub, where you can post your policies and you can post all your notifications that are required as new legislation comes out, so you can demonstrate that the employees received it. Turning to the ADA, another big statute that applies. And remember, the ADA applies from day one of employment, unlike the FMLA. And what are the key takeaways from the ADA here? People with COVID could fall under the category of being regarded as disabled. So if you treat them differently because they've been exposed or they think they've been exposed or they had it, that could trigger an ADA claim. What does that mean? That employee who's working from home, who's ill, you have to engage in the interactive process. And what does that mean? It means talking to them. It means talking to them about what accommodation they may need in order to do their job. And what could that mean in COVID times and working from home? It could mean access to files and documents. We have had matters where employers have restricted access to documents. You can only be in the office. Well, employees don't want to go in the office. And if they have an illness that makes them susceptible to COVID or a premorbidity that could hurt them, you may want to consider opening that access up to that employee as a reasonable accommodation. Another issue is adequate access to technology and resources. If they need a new piece of technology to work from home due to an ADA covered issue, you must consider it as part of the reasonable accommodation process. There may be ways to compensate for them for that. Some states also are allowing employees to address that in their taxes. Some of the things Judy talked about. But you must engage in the interactive process, talk to them, see what they need. Don't just dismiss it, because if you do, that's a failure to accommodate. And that is something the ADA likes to look at a lot. The other thing to remember during this time period, what are the essential functions of the job? If you're going to deny someone teleworking as we start to reopen and you want them back in the office, your job description better make it clear that that position is not subject to virtual work. Make sure your job descriptions are clear. Make sure they have the essential functions of the job in the description. Number two, and this quote, magic words, is right out of case law for this circuit. There are no magic words needed to put an employer on notice of a disability or the employee's need for accommodation. If that employee starts reaching out and they need something to do their job due to an illness or perceived illness, or with COVID, a concern about reporting to work, you have to treat it as an ADA and go through the interactive process. Again, a reasonable accommodation could also be FMLA leave, FFCRA leave, and those can work together. If you're not going to provide the accommodation, make sure you document why you didn't do it. The only real defense is that it would pose an undue hardship on the business. That's a difficult case to win, not something in this environment I would want to go before a jury with. So keep that in mind. Now, another big issue that we're dealing with, childcare issues. This is where the Department of Labor comes in again. Childcare is not compensable time from work. So in other words, you do not have to pay for an employee while they're taking care of their children. It should be scheduled. There should be clarity on it, what you're doing, when the hours are being taken off, etc. But employers do not have to accept an employee working with the children, running around in the background and also trying to take care of them. You may want to look at your virtual working, teleworking policy and revise it to make sure it's clear that teleworking, virtual working is not a substitute. The federal government is very strict on this, and in many agencies require, prior to COVID, employees who are working virtually to have proof of daycare services, etc. Now, with that said, it is a difficult work environment. Schools are closed. Schools are back to hybrid. Daycare may be closed, etc. We don't want to be uncaring here, and we want to try to make it work for the employer. So these are some things to consider. Implementation of a policy that prohibits virtual calls or Zoom meetings during specified times, like lunch when the kids are on a break or something like that. You want to make sure any breaks are scheduled so everybody knows. Make sure they record all of the time worked accurately and all of the time they're not working. And something to keep in mind with the FFCRA, if your employees have not used up all their time under the FFCRA, it has been amended to allow for taking it partially. And what I mean by that, what they're now saying, if an employee is taking care of their children because the school is not fully open and the school is on a hybrid program where they go to school 2 days and are home 3, that employee can use FFCRA leave for those 3 days. If, on the other hand, the school is open or even hybrid and the child could go to school for part of the work week and the parent decides not to allow it, that's optional, and they're not entitled to take FFCRA leave if you don't want to give it to them. With that, keep in mind your state and local laws as well. We're seeing a lot of action in that arena, especially in DC. The DC Supplemental Emergency Act, what this essentially did was eliminate the 1-year requirement to be eligible for DC family medical leave. So it applies right away to employees who work for an employer in the district. Number 2, it allowed employees to utilize the DC Sick and Safe Leave Act to get full pay while they may be out on FFCRA leave. Something that not a lot of people know about, but it's something you need to be aware of. We have gotten many claims in where employers have just messed up when allowing the FFCRA leave or FMLA leave and moved to terminate an employee without giving that option. And that's going to lead right to litigation. So what should employers do? What are your best practices and policies? Make sure your employees know all EEO policies are in place. We are seeing sexual harassment claims that I can't even describe the fact patterns, but people working from home and stuff going on in the background or calls late at night or Zoom meetings at inappropriate times. Make sure everyone knows, take any complaints seriously. Number 2, comply with your FSLA wage and hour laws and make sure you have your policies out there and the employees know how to record their time. And if you're going to allow breaks in the day, make sure they're scheduled and you've documented that people know you're not to bother the employee during that break time because you're not paying them during that time. If there's an injury, OSHA could be triggered, even if they're working at home. And number 2, workers' comp still applies. Don't forget that. Again, the FFCRA and all of these new guidances from the CDC and the Department of Labor, they all typically require posting. And now that we don't have the meeting room or the lunchroom or the water cooler to post these notices around, consider creating a virtual HR site for your office. That will help you comply with the posting requirements and be able to demonstrate that you complied with the law. Next, your job descriptions. We talked about that. Look at them. As we get back into the workplace, you're going to have people who don't want to come to work and you may need to replace them. Make sure that job description is clear. If that job is not to be done virtually or that's not an option, make it clear. Make your essential job duties clear in those job descriptions. Continue your performance reviews and evaluations and performance deficiencies. If you have to put someone on a PIP, do it and make certain that you document it. Next, we hear a lot of complaints about morale, losing the feeling of esprit de corps, et cetera. These are some ideas in the literature that we're seeing. Virtual group events like on Zoom or something like that. Other types of uses of technology to keep people communicating, keep your lines of HR communication open so that you know if there's a problem and you can nip it in the bud early. Now, we have just a couple minutes. I'm going to go through this quickly. The return to work considerations. Again, these are the links to the CDC guidance and their pamphlet on their guidance on how to return to work. Review them. They're important. Make sure you demonstrate you incorporated them into your policies and that you've trained your employees on these policies as we begin to open up again. OSHA. What does OSHA want? Essentially the same thing as the CDC. Clean workstations, PPE available. Make sure the building is appropriately opened with social distancing, hand sanitizers, et cetera, hand cleaning stations. Show that you've done that. That will help you a great deal to defend any suit. Again, the CDC guidelines to follow. Remember the ADA, always involved here. Remember your leave policies, both federal, state, and local. FFCRA, FMLA could be available to your employees as a reasonable accommodation or just to use the leave as they deem appropriate. And that's all we have for this section. Judy, I can turn it back to you.
Okay.
If you'd like. All right.
I think we lost the slides.
Okay. Should we go to questions?
Yes, just monitoring the chat box here.
I can, while you're looking at that, there was one question we got earlier about trying to have a uniform policy on leave, et cetera, as employees are virtually working all over the country. That's going to be very difficult to do. And you could run afoul of your individual jurisdiction leave requirements. I would try to stick with the policies you have in place now, unless you are changing the employee status to working in another state under the tax laws. If you're taking that step, then you might have to consider changing your leave policies, et cetera, to fit that state or jurisdiction's leave policies.
I'm trying just to bring back.
All right, I'll add one more thing for the DC employers. Keep in mind the Universal Paid Leave Act and the 0.62% tax that the employer pays on employee wages. That act only applies if the employee works 50% of their time in the district. If you are moving to a complete virtual setup or a setup where the employee is working virtually a great deal of the time, 60, 70%, you don't need them coming in the office, something you may want to audit and take a look at as to whether you could try to exempt out of that tax for a certain number of your employees.
Okay, some of the questions in the chat box, just most recent came in. How do the wage laws affect salaried employees?
Well, if your salary, you got to be paid. If you worked 1 hour of the week, you have to be paid. So what we covered there was really more directed at failure to pay overtime or pay hourly employees their wages due. Exempt employees, they get paid whether they're working the full day or not, generally speaking.
Will the recording or slides be provided? Yes, you'll be sent a copy of the slides, and also I'm not sure about the recording. Maybe Joe can address that, but we'll be sending a copy of the slides to all the registrants. Question here, Tom, I think it's for you. Our offices are open, but we are still permitting remote work. We have stated that we don't have a budget to supply ergonomic equipment for both home office and the regular office. Employees are trying to bring office equipment home despite us supplying them with a disaster relief one-time payment. Are we supposed to incur the cost of ergonomic home equipment and in-office ergo equipment?
You're going to have to look at that on a case-by-case basis. Generally speaking, I would say no. But if it rises to the level of an ADA accommodation issue, it's something you're going to need to consider. And depending what jurisdictions you're in, states are now coming up with requirements that employers may have to pay to help outfit the home office, and also their tax breaks potentially for the employees, depending on your jurisdiction. But again, you're going to want to look at that on a case-by-case basis.
We have a few minutes to take a couple more questions, but before I do that, I just want to say this slide 43 and 44 show upcoming events that Carr Maloney is hosting. You'll see Hot Topics Employment Law Updates October 6th, and also their COVID-19 resource hub available on their website, and you can sign up for email notices. And for Councilor Buchanan and Mitchell, we have 5 upcoming virtual presentations. These are complimentary. I'm involved with 3 of them in terms of the financial planning for mid-career professionals, estate planning, and our retirement and life care planning seminar. And then we have a market update, 2 market updates planned. And I'll leave it on this slide in terms of how to contact us. Going back to questions, an employee goes to Greece to live with his sister until the end of the year, working from Greece. Are we able to just continue DC? So I would say that international issues are kind of beyond the scope of this this seminar. But you know, if the individual is at least still paying in DC, that would be better than not paying at all and just basically trying to say that they're overseas. Do you know if workers' comp covers remote workers out west suffering from smoke inhalation or any injury, illness related to wildfires?
I do not know this. It would, again, depend on the state, but that doesn't sound like an injury caused due to the work environment. That's more of the wildfire and environmental issue. It's going to be governed by whatever state they try to file the workers' comp claim in, but generally speaking, I would not expect that to be compensable.
What is the difference between remote workers and telecommuting employees?
Same thing. In my presentation, I was using them interchangeably.
I would say so. In my mind, I think sometimes that you have permanent remote workers. And that is, you know, a lot of companies now are hiring workers that just do work from their homes in a different state on a permanent basis, versus telecommuting would be more the convenience of the employee, where their actual still Nexus would be their regular workplace that the employer provides. What are the penalties? What are the penalties for violating these tax provisions look like? It's going to be by state. And, you know, hopefully we're going to see some relief because by not complying and paying in the right amount of taxes throughout 2020. When you go to file your tax returns in April of next year, could be a rude awakening. And so, again, I would seek out and try to reach your congressmen and senators. We do need some kind of relief here from the Hill. What is the four-prong hierarchy for determining unemployment? I can send that to you via email. What will the impact on not-for-profit organizations be addressed? So, I mean, the not-for-profit as employers are still going to be subject to the same rules with regard to withholding for their employees. You know, unless they file a 990T, they're not going to have to worry necessarily about the business income tax side of it, but certainly the payroll tax, workers' compensation considerations that Tom addressed, all that will apply to not-for-profits as well as for-profit entities. And I think that's it. Want to thank you very much for attending our seminar. We're thrilled with the turnout. We've got a lot of, I think we were close to 170 or so attending. So appreciate that. And if there's anything that we can do to assist you, please feel free to reach out to Tom or myself. Thank you.
Thank you all.
Bye-bye.